Parties own the voters, and anyone else who challenges them is siphoning votes from one over the other. As if we don't stand for a country where you have an equal right to run for election. As if it isn't bad enough that the ballot access obstructions raise serious civil liberties problems for candidates, and when candidates have civil liberty problems, voters have less choice on the ballot. And that's when you see bright people who agree with you all over the country entrenching the two-party tyranny, because we all know only one of them can win, therefore we pick the least of the worst and make no demands on the least of the worst, and therefore the corporate interests pull both major candidates in their direction in the election year, and more humane, progressive values, they're not tugging in the other direction because they don't want to upset John Kerry, who didn't have to worry about the anti-war vote. And therefore he became an advocate of more soldiers in Iraq, and he wouldn't have withdrawn from Fallujah. Remember that in the debate? He out-hawked Bush and got a laudatory editorial in the Wall Street Journal. Because he didn't have to worry about millions of people. Half the population, 60% at that time, were against the war, wanted us out of there. Lawrence Lessig, bright man. See what happens? Normative immaturity leads to either cognitive dissonance or a shortfall in the desire for a fuller awareness of the phenomenon, such as ballot access and the treatment of third parties and minority candidates, which had far more access in the 19th century. That's why we got these progressive agendas moved. It was easy to get on the ballot. Sometimes in some states, all they had to do was print the ballot. You were on. Much, much more onerous today. Let's look at your curriculum. What determines your curriculum? Well, obviously the job market. There's a lot of jobs in intellectual property. You're likely to have a course or two in intellectual property. If there aren't many jobs in prosecuting corporate crime, you're not likely to have corporate crime courses. It's much better now than it was. You know, a wider choice of courses. But there's still this corporatism behind, because it reflects the massively imbalanced deployment of lawyers in our country. Something we never discussed in law school, not once. Even though intuitively we knew that 90% of the lawyers represented 10% of the people in the corporations. And if you don't talk about the deployment, and I know the law school is trying to give you $1 million fund to help you go into social entrepreneurship, etc. If we don't talk about the deployment, we can't bring the cases. We can't challenge the regulatory agencies. They're too technical to be done without attorneys, without lawyers. Earlier this year, I talked about how we never discussed the difference between an attorney and a lawyer and at the law school. Lawyer has a larger obligation to improve the administration of justice. Attorney represents the client. Ideally, there would be one person. We'd both be attorneys or lawyers. We also never discussed what offices of the court meant. Students are going to be officers of the court. What does that mean? That means they're quasi-official people with certain obligations. Not just an obligation to get nice retainers. But that hasn't been given content either, because it hasn't been given intellectual content at the law schools. So the judges don't really know how far they can go to say to a lawyer, these people are unrepresented, they can't get a lawyer, you are going to represent those people because you're an officer of the court. You have a privilege to enter a monopoly profession. And there's a reciprocity to that. Now look at the corporate control issue. The most sophisticated system of concentrated power in the history of the world is in the United States. Because they do it in a way where we grow up accepting it and therefore don't feel it. For instance, have you ever met a Harvard Law student who refused to sign a contract of adhesion without editing it? You don't even have to sign now. You just click on and you're stuck. Whatever happened to the freedom of contract? How many hours in your contracts course do you spend on contracts of adhesion? That's most of the contracts we'll ever sign. Credit card, insurance policies, installment loan contracts, bank deposit cards, you name it. They're all fine print. They're all one-sided. And they also come now with new curlicues that the judges don't seem to be upset about, other than perhaps mandatory arbitration, which keeps you from going to court against your favorite insurance company or bank. It now has provisions where they say, vendor reserves the right to alter the terms of the contract as vendor sees fit. There's no more contract. You think anybody in law schools are really upset about that, other than maybe 6 professors? We've lost our freedom of contract, but we grow up corporate accepting it, so we're not upset with it at all. We don't cross out a paragraph here and double the warranty, get rid of this clause and that, and sign it and say, in the margins. And most contract courses deal with negotiated contracts between businesses, labor unions, business, etc. They don't deal with contracts of adhesion. Let me just ask you, what are you going to be doing when you practice? What are you going to be doing with the following patterns of corporate control? And if we had more time, I'd love to be challenged on this. We're talking about here severe imbalance, not 100% control. Severe imbalance between the artificial entity known as the corporation and the people who are supposed to run this country under we the people preamble to our Constitution. The word corporation does not exist in our Constitution. The word company does not exist in our Constitution. Why have we allowed it to dominate us? Because our courts, not our legislature to begin with, in the late 19th century, transformed these inanimate objects into persons for purposes of the 14th Amendment and then for purposes of almost the entire Bill of Rights, except the 5th Amendment. Justice Scalia apparently has no problem with this. He's a judicial originalist, and yet he has no problem with giving inanimate entities all the constitutional rights we have, except the 5th Amendment, in addition to the privileges and immunities that corporations have that even a billionaire couldn't begin to approximate, because they are inanimate, they are global, they create their own parents, holding companies, subsidiaries, go bankrupt, retention, executive salaries, enormous double standard under the laws. Even in the tax system, can you believe it? With all the ability to go down to a much smaller net tax burden, corporations' highest tax rate is lower than that of individuals.